All right. Good afternoon to those of us that have joined in person. Thanks very much for coming. And to those of you that are attending virtually, thank you very much for attending virtually. And you're not coming, but you're close enough. My name is Joe MacArthur, and I am pleased today to be joined by members of the Vancouver International Arbitration Center's Rules Committee. And the purpose of today's webinar is really to introduce our new international rules, which come into effect on July 1st. And first, I'll do some quick introductions of the people responsible for these new rules. Starting immediately to my left, I'm joined by Ludmilla Herbst, QC. Ludmilla is a partner at Ferris, practicing in disputes for about 23 years, and also a director at the Vancouver International Arbitration Center. In addition to being named Queen's Counsel, Ludmilla has received numerous accolades over the years, well-deserved, and is perhaps best known in the arbitration world as the so-called co-author of the indispensable and off-cited text Commercial Arbitration in Canada. I know my copy is well thumbed and has pages ripped out in every which way. So thanks very much for joining us today, Ludmilla, and thanks very much for being on the board and on the Rules Committee.
Thank you.
Next, I'm going to skip Ariel. I'll come to Ariel at the end. At the end of the table, joined by Alexandra Mitrodotis. Alex is a partner in Vancouver at Faskins and also a director at VanIAC. Alex practices commercial litigation and arbitration and has been recognized in Who's Who Legal Arbitration as a future leader. And there's a number of other recognitions that Alex is one to watch in the domestic and international arbitration space. And so congratulations today, you get a chance to watch her. And sitting in the middle is Ariel Solos. Ariel is an integral part of the Blake's arbitration group, which has been recognized by Benchmark as Canada's Arbitration Firm of the Year for the past 5 years. I just thought I'd put that in somewhere. I didn't know where to put that plug in. That seemed like a kind of an appropriate time. Ariel's practice is focused on domestic and international arbitration, often involving large infrastructure projects. And she is a regional director of the Society of Construction Law and has been recognized this time literally as one to watch in Best Lawyers. I am chair of the Vancouver International Arbitration Center and also chair of the Rules Committee. And in my spare time for the past 27 years, I have practiced primarily international and domestic arbitration as arbitration counsel and occasionally as arbitrator, again, both in domestic and international arbitration. So that's who our panel is. We hope to keep this day relatively free-flowing. So if you have questions, if you're on the floor, please, if you're here, please don't hesitate to ask questions, and we'll do our best to answer them. But I thought I'd start with, by way of kind of a brief introduction, really about why the new international arbitration rules. Why now? Why do we have these? And I think the first reason is kind of a simple one. It has been many years, in fact, a couple of decades since VanIAC, formerly the BC-ICAC, amended their international arbitration rules. And over those 2 decades, there's been a lot of trends in the international arbitration space, and you see that reflected in a number of the rules of other international arbitration institutions. And we wanted to make sure that we had international rules that kind of met those modern trends. So that was really one of the big pushes for the new international rules, was to bring them up to date as to what's happening in the marketplace and best practices in the area of international arbitration. And I think you'll hear today from some of the other panelists about what I'm talking about there in terms of the newer things that you'll see in our rules and some of the other institutions' rules as well. So that's the main first reason. Now, the second reason relates to our new domestic rules. So in September of 2020, VanIAC introduced its new domestic rules, and these coincided with British Columbia's new Domestic Arbitration Act. And there is a bit of a shift in focus of the new Domestic Arbitration Act, in that it included a lot of procedural steps, a lot of procedural elements that weren't there in the old Domestic Arbitration Act. And what that meant is a lot of the rules that used to be in VanIAC's old domestic rules were really unnecessary because they were dealt with already in the Act. And so when we put together VanIAC's new domestic arbitration rules in September 2020 with the new Act, what we did is we focused on the benefits, new benefits that would be there by having your arbitration administered by VanIAC, and really left the procedural elements that were already in the Act rather than duplicating them in the domestic rules. And so the Domestic Act of BC and the rules, the new rules that we introduced, work very well together. They're meant to work together, and people have expressed, at least for the most part, that they're quite happy with the way the Act and the rules are now working together. However, what we did also find was that while our rules worked very well with BC's new Arbitration Act, there were parties in Canada in less, let's call it, enlightened provinces, at least for those of us in BC, who were using VanIAC's rules, which is great, but had their arbitration seated in a different province. So Alberta comes to mind, Ontario, and other provinces. And a lot of the procedural elements that are in the new BC Domestic Act aren't necessarily found in those other acts, like in Alberta. And what some of our panelists found, some of the panelists sitting as arbitrators found, is that this was causing some difficulty because there were certain things that were in the Alberta Arbitration Act that governed only because our rules didn't deal with them. So such things as costs, and the summary procedure for costs that's now in the new BC Arbitration Act used to be in the VanIAC rules, but we took them out because the Act dealt with it. Well, in Alberta, they've got different rules that would probably be ones you wouldn't necessarily choose to deal with costs, and there's a bit of a conflict there. So there's really a gap when you use our domestic rules in other parts of Canada. And we were concerned about that gap because one of the things we want to do for VanIAC is to make it clear that as an arbitration institution, we can administer your arbitration wherever it is. And one of the ways we thought we could address this issue is to take our new international rules and have those also apply to arbitrations that are seated outside of British Columbia. So the new international arbitration rules that come into effect on July 1st will also apply to arbitrations that are administered by VanIAC, but that are seated in Calgary, Toronto, Flin Flon, wherever, somewhere else in Canada. And we think that's going to work better because we've closed those gaps that existed between our new domestic rules and some of the other arbitration acts. And we've put some of those procedural features that we like in the new Domestic Act, we made sure that they're back into the international rules that would apply to domestic arbitrations, but outside of BC. And of course, one of the things we wanted to make sure is that we had these international rules to encourage the use of VanIAC internationally. And what we think we've done, and you'll hear about it from the panelists, is we've taken some of the things that we've found in the past 18 months that have been working very well in the domestic rules that we introduced in those domestic rules. We've incorporated those into our new international rules as well. And so some of those things, such as the emergency arbitrator rules, the availability of an emergency arbitrator, are incorporated into the new international rules. And the expedited procedures, which have been quite successful under the domestic rules, are also incorporated into our new international rules, but with a higher threshold. And so I'll let the others speak about that. But I think we're well positioned with these new international rules to expand VanIAC's footprint for arbitrations outside of BC, international arbitrations, and domestic arbitrations that are seen outside of BC. And that was really one of the focus of getting these new rules. And the Rules Committee spent a fair amount of time in putting together these new rules and looking at other rules from other institutions and seeing what best practices are and gathering information. And I should also say I neglected to mention that there was a fifth member, kind of like the fifth Beatle, who is missing today, but Craig Chason from BLG. Craig provided a lot of insight in terms of international arbitration practice, and unfortunately, we scheduled this on the one day that Craig wasn't available, but everyone else was. So anyhow, anyways, thanks to Craig as well, and thank you to all the members of the Rules Committee in helping with these rules. So now I think I'm going to pass it on to Ariel just to give a little bit of an overview of how under the new international rules, appointing and challenging arbitrators is working. Ariel?
Thank you, Joe. And so when it comes to appointment and challenge of arbitrators, we really haven't reinvented the wheel in these provisions. The default is that a sole arbitrator will be appointed unless the parties agree otherwise. And the expectation is that the parties will coordinate, that they will agree on an arbitrator in a timely way within 21 days. You have about 3 weeks to agree on a sole arbitrator. If a dispute needs to be resolved by 3 arbitrators, the procedure is different. So in that case, the claimant will appoint an arbitrator for confirmation in the request, and the respondent will appoint an arbitrator in the answer, and then those 2 arbitrators will appoint the chair. Similarly, if there are more than 2 parties to the arbitration, so you have potentially multiple claimants, multiple respondents, the claimant or group of claimants will appoint one, and the respondent or group of respondents will appoint the other when it comes to a 3-arbitrator tribunal. So if the parties can't agree, which sometimes happens in litigation and arbitration, there is a procedure for dealing with that as well. And so that's either if the parties can't agree within the 21 days on the sole arbitrator, or a party fails to appoint an arbitrator in the manner set out in the rules. The procedure that will then come into effect is that the applicant, so the party seeking to have an arbitrator appointed, will provide VanIAC with the names of any arbitrators that have already been discussed between the parties. VanIAC will then deliver to each party a list of 5 names of proposed arbitrators, together with a brief description of each proposed arbitrator. And the hope then is that the arbitrators will, the parties will discuss the list and come to some agreement on the arbitrator. But again, if the parties aren't able to agree, then within 5 days of the list being delivered by VanIAC, each party should respond by delivering a list of its order of preference for those arbitrators and any name to which they specifically object. At that point, VanIAC may either appoint the tribunal from the names on the list within 5 days, or alternatively, VanIAC might deliver a second list to each party containing 4 other names. And the same procedure would take place at that point. Either the parties can hopefully agree on a name from that list, or alternatively, they'll respond by delivering to VanIAC a list with their order of preference for the arbitrators and any name to which they object. And at that point, VanIAC will appoint an arbitrator. There is no third list, so that is the end of the line for appointment. And when it comes to emergency arbitrators, so we'll talk a little more about that later, but if a party needs to bring an emergency application before the tribunal has been constituted, in that case, VanIAC will appoint an arbitrator, an emergency arbitrator, within 2 days of the request for interim measures. Moving to challenging an arbitrator, the challenge provisions for emergency arbitrators and arbitrators generally are quite similar, so I'll only go through one of those. And a party may challenge an arbitrator where either they failed to perform the duties, where circumstances give rise to justifiable doubts as to the arbitrator's independence or impartiality, or where the arbitrator doesn't possess the qualifications agreed to by the parties if the arbitration clause at issue contains some really specific specifications, which is, as always, something to consider when drafting your clauses as well, whether you want to leave open the potential for disputes about qualifications. So a party wishing to challenge an arbitrator needs to deliver written notice to the tribunal and the other parties, setting out detailed reasons for that challenge, no later than 15 days after becoming aware of the circumstances giving rise to that challenge. At that point, either the challenged arbitrator can withdraw, or if the other parties to the arbitration agree to the challenge, they will be deemed to have withdrawn. And if that doesn't resolve the issue, the tribunal will decide on the challenge. So I think that covers the challenge provisions and the appointment provisions. Are there any questions specific to those? Or any comments from people's experiences with challenges?
I would never challenge an arbitrator.
None of us would.
No. And I actually think it is a relatively rare circumstance. It does happen, but I think it's relatively rare.
I would hope.
Yes, but it's good to have the rules in place to make sure if there is a challenge that you've got a procedure to deal with it.
And on the topic of interim measures and emergency applications, I'll turn it over to Villa to talk a little more about this.
All right, thank you very much. And so traditionally, among the reasons that parties might have been deterred from using arbitration as a means of dispute resolution as opposed to the courts were some of the complexities that arose and some of the uncertainties that arose around interim measures, what kinds of interim measures might be available from an arbitrator as opposed to a court. And the issue that's been flagged a little bit before through Ariel's comments, the issue and Joe's in part, what happens during that period when you might need urgent relief, but an arbitral tribunal, the arbitral tribunal that will eventually decide the merits of the case, hasn't yet been constituted. And that the prospect of being left in limbo or left without recourse other than the courts was a bit daunting for some parties who thought that might arise in their case and might have been a deterrent from using an arbitral process at all. So the new international rules address both those kinds of things, what kinds of interim measures are available from an arbitrator, and what happens in that critical window before the appointment of the eventual arbitral tribunal that will decide the merits. Some of the provisions in terms of the kinds of interim relief available aren't new. They echo some of what was found in the old rules. But as has been signaled, the emergency arbitrator provisions, the arbitrator who bridges that gap between starting an arbitration and the actual appointment of a tribunal are new and very important. So in terms of what kinds of interim relief is available, the VanIAC rules, as they now stand, and as they will stand after July 1st, provide that an arbitrator can order relief that is appropriate. So it's a broad scope and particularized among the sorts of relief that are available in Rule 26 are security for all or part of the amount in dispute. So something that could be very useful in some cases, preservation, storage, sale, or other disposal of property that's at issue in the arbitration, and any other kind of relief that the tribunal might ultimately have the ability to award as part of their final award, but accelerate it to an earlier stage on an interim basis. Now, while those sorts of relief are available from an arbitrator, of course, a party still isn't barred from going to a court. if they feel it appropriate or some exigency in the arbitration makes it important for them. Rule 26 of the new international rules affirms the general principle that seeking interim relief from a court isn't treated as a waiver of the right to arbitrate. It's not deemed incompatible with the rules as a whole. Although, of course, as a further sort of balancing factor, if you do go to court, when you do have that ability to seek relief from an arbitrator, the court might not necessarily hear you. So there have been some cases, including African Mixing Technologies from the BC Supreme Court, about when the court should actually step in. Should it defer to an arbitrator or a to be appointed arbitrator when the sort of relief that's being sought by a party from the court is really relief that would preempt what the arbitrator does at the end of the day, if it is something that the arbitrator could award. So there's still that balancing out, but certainly the new rules make clear that you do have a lot of opportunity to seek relief from an arbitrator, and it's broad and it's fairly specific. Now, on the arbitral front, so returning squarely to that forum, what the new rules provide in terms of sort of a type of relief or the opportunity to obtain relief is a bit of something that might not be surprising, but is newly expressed and more robust, if I can put it that way, after some international controversy. And that's the fact that you can obtain interim relief on an ex parte basis. So as a party, you can seek relief from an arbitrator without having given notice to the other side in the appropriate circumstances, of course, not as a general rule. The fact I say it's after some controversy and that's of some note that the rules are expressed in this is that there was some feeling among some arbitration practitioners, some arbitrators, that, you know, if you're in a consensual setting, as arbitration is, you derive your authority as an arbitrator from a contract between the parties for the most part. Should you really be granting relief when one party doesn't know about it, doesn't know that it's a prospect? But I think as a general sort of tendency, and there were other sort of general concerns about ex parte relief as well, not that different from the kinds of concerns that might reverberate in a courtroom. You know, is it really fair? Is it appropriate to be granting something that the other side doesn't know about? What are the procedural protections? So the new rules certainly make clear that relief is available without notice in the right circumstances. And that recognizes that sometimes there's a real need to avoid injustice by those means. And also, I think, a sense that the integrity of the arbitration process and its use as an institution is bolstered by not ceding ground to the courts, not handing it over as, you know, anytime you need ex parte relief, go to court rather than go to an arbitrator. Better to preserve it within an arbitrator's scope. So there in the rules, it is. Rule 27 provides that there are circumstances for potential ex parte relief, but there are safeguards. And many of them are familiar to anyone who practices in the courts as well. So the circumstances have to be exceptional for ex parte relief to be sought on an interim basis. There's a disclosure obligation. So an applicant who is seeking relief without notice has to disclose all circumstances that are likely to be relevant to the arbitral tribunal's determination whether to grant or maintain the order. There has to be a chance for the party against whom an award is made, or a preliminary order on an ex parte basis is made, to challenge it. So there has to be notification given that the ex parte relief has been awarded, and at the earliest practical time, the party against whom the order is made has a chance to put their own case forward. And in any event, a preliminary order, so one that's granted early on an urgent basis in this form, is time limited and not enforceable in the courts. So, although it is between the parties. So that already signals ex parte relief might very well be sought in exceptional circumstances that are urgent. More generally, in terms of urgency, sometimes urgency that still allows you to give notice to the other side is that topic that I was referring to earlier. What happens in that bridge period, the interim period where you have a need for relief as a party, but your arbitral tribunal, the tribunal that will decide the merits at the end of the day, hasn't yet been established, that you're still looking for someone in the way that Ariel noted, that there's still progress in motion on that front, where there's not yet been appointment of the arbitral tribunal. Do you have to go to court? And the answer under the new rules is no, you don't. There's a provision in Rule 32 for the establishment or involvement of, Rule 29, but Rule 32 is a protection for an emergency arbitrator, but you can, as parties at the outset, opt out of that provision. So it's possible to agree in your arbitration agreement that you're not going to have an emergency arbitrator step in, but otherwise this rule applies. Ariel's signaled as well, if there is a desire for recourse to an emergency arbitrator and an application for that to VanIAC, that emergency arbitrator has to be appointed within 2 days of receipt of the request. That emergency arbitrator isn't going to be the same person as decides the merits of the dispute unless the parties agree otherwise, and that's provided for under Rule 29. The emergency arbitrator is, as befitting the name, supposed to act quickly. So under Rule 31, the emergency arbitrator is to issue any interim measure or preliminary order within 15 days of appointment. So this is intended to be a swift process. And again, ensure that a party who has committed to arbitration, who set this process in motion, isn't left with no option but to go to court. There is an ability to seek some relief through VanIAC's intercession and the appointment of an emergency arbitrator to step in. As signaled by the fact that the emergency arbitrator isn't generally going to be subject to agreement of the parties, the person deciding the merits at the end of the day, while the emergency arbitrator might still have some power to issue the interim measure or preliminary order applied for after the arbitral tribunal has been appointed. So assuming that process is still going on in terms of seeking out and appointing the tribunal, and the emergency arbitrator can spill over, but doesn't have any further powers after that. So it's a relatively compact process, but sometimes can be a necessary and important one. And to Joe's point earlier, in terms of watching trends that have been occurring in other institutions and what other bodies have done internationally in terms of their rules and what practice has been implemented, this is one of those facets of practice and rules that's arisen elsewhere, including under the ICC rules. And it is something that, as Joe mentioned as well, has found its way into the domestic rules, or is one of those areas where there's been a domestic VanIAC innovation that the international rules are now adopting. And there has been some take up in terms of emergency arbitrators in the domestic forum. Of course, we'll see how often it comes up within the ambit of the international rules, but it's an interesting and potentially very useful development. And while I haven't had experience with international emergency arbitrators myself, I think, Joe, you've had some in terms of the ICC.
We had some last summer. We had an emergency arbitration served on our client, an application for interim emergency relief. That was under the ICC rules, not the VanIAC rules. But similarly to the VanIAC rules, I mean, as Lenilla said, it's a 15-day process from appointment to issuing your award. And it's something similar under the ICC. I can't quite recall what it is. But it is, if you're an arbitrator, it is a real challenge. Because in that 15 days from appointment to issuing the award, you've got to set a schedule to do whatever you think is necessary in order to give a fair hearing on this interim measure and issue an award. So it doesn't give you a whole lot of time. And in our experience with the ICC emergency measures that we dealt with last summer, the time period is so constrained. And I at the end of it, I think all parties felt very badly for leaving a big pile of stuff for the arbitrator to figure out and issue a reasoned award over 3 days, if I recall. So it was, we felt a little bit badly for him. But of course, as the respondents, we gave them a few easy outs, so we wouldn't have to write a long award. So, so
Oh, very nice of you.
Yeah, we were very, we were just thinking of the arbitrator, and it was in the summer too. So and crossed over some holidays. So, but it's actually a very effective process, I think, and does take away the need of going to court when you've got an arbitration clause and you want some preliminary relief. Because always that concern is getting that tribunal appointed before they could make that decision. And here you've got a way of dealing with that, I think, in a meaningful way. And I think in the ICC thing, I mean, we won, so it worked very well. It's a wonderful process. But the ICC in particular, getting your tribunal appointed can take quite some time, requires ICC court approval and so on. So it's a much longer process than we have under the VanIAC rules. And so even in that context, the emergency application becomes even more important to make sure it's available as an option for parties. And again, as Lanilla said, for VanIAC, you can opt out if you like, if you don't want to include that. And I think the real concern that people have with it is that ex parte ability. The nature of that ex parte award that you would seek at the very front end is to make sure that the kind of the extent of that initial injunction, if you will, or interim measure, is meant to protect whatever the application for an interim measure is until that's heard. So the idea is if it's, let's say, a ship called the Mariva that's in port, and if you deliver your application that the Mariva not leave port, there's nothing to stop them from just the Mariva leaving port. But the idea here is if you deliver your application at the same time, there's a preliminary order from the emergency arbitrator saying the Mariva can't leave port, and here's an application that we're going to deal with the decision of whether or not, as an emergency measure, the Mariva can't leave port. That gives you a little more protection for that interim period. And so that's the idea behind it, and I think it has the ability to work really well in the right, relatively rare circumstances. And it's unfortunate, well, for many reasons, that Craig isn't here, but also it's unfortunate because Craig has had experience as a emergency arbitrator under the VanIAC domestic rules, and that he could share some of that experience, but he's not here. So if you see him, ask Craig about it, and he can share that experience as well.
Say we sent you. And
yeah, that's right.
The only other thing I'll add on the interim emergency procedures is there's one thing that by virtue of the very nature of arbitration, we can't get over. And that's, of course, in some circumstances, you may need or may think your client needs interim relief or indeed final relief against a party who's, or I should say, not a party to the arbitration agreement. And so sometimes you may still be considering whether you should go to court because you need to latch on to somebody who's not an arbitration party, not a signatory, not someone you can somehow sort of draw in by virtue of piercing the corporate veil, the exotic doctrines that might apply, or so there, that's still out there, and that's just something inherently tough when you're in an arbitration consensual process. But otherwise, to the extent possible, I think the rules are intended to facilitate and give options so that your clients, parties before you have an ability to seek the relief that they need in the time that they need it. And speaking of times that they need it and expedition and all other modes of trying to facilitate matters, I'll turn it over to Alex, I think, who's going to cover off other facets of the rules that address other points.
So before getting to expedite arbitrations, I'm just going to say a few things about virtual hearings and our online platform that we've developed. So our new international rules provide specifically for the ability to have virtual hearings as an option where either the parties agree or the arbitrator or the arbitral tribunal has directed it. And they can make, the arbitral tribunal can make directions with what platform that's going to be on and any other logistics around that technology. But what we have incorporated right in those rules to address the privacy concerns that arbitration has is that the only people who would be entitled to attend that virtual hearing would be the parties, their legal representatives, witnesses during their examinations, the tribunal secretary, the tribunal, and any third-party service providers like interpreters, transcription services, technology services, etc. And the procedural order will address who it is that can attend that virtual hearing. And so obviously in the last couple of years, the large majority of VanIAC's hearings, if not all, have been virtual. In-person hearings are slowly starting up again, but moving past the pandemic, that is an option if it makes sense for specific cases where you may have parties in different jurisdictions or even different provinces or witnesses in different locations. For in-person hearings, we have arranged for preferred rates with charade reporting for VanIAC arbitrations. And so we've now at least had one that's been held there under our new domestic rules. And so keep that in mind when you're scheduling in-person hearings, that you can get a discounted rate through charade reporting for your arbitration. Our online platform that we've created at no cost to the parties is it enables the parties to upload all of their file materials in one online platform. So rather than exchanging things by email or USB key or file sites or whatever you have, that you can put your pleadings, your exhibits, your memorials, your expert reports, everything from beginning to end on the online platform, and the parties and the arbitrator and VanIAC all have access to that. And VanIAC can also upload all of its correspondence, that's mutual correspondence between the parties there, and can also upload any private communication. So for example, invoices that are sent to each party can all be found in one place on the online platform. And the arbitrator can also use that platform to upload any procedural awards and any procedural orders and any awards as well. So that platform is found online through our website, and our staff can assist anyone who's wanting to use that platform. So on to expedited arbitrations. Faster resolution is a key benefit that arbitration is intended to provide for business disputes. And so when a particularly fast outcome is needed, expedited arbitrations can permit the parties to get a faster result. And so under our domestic rules, we've actually had 33% of our cases be expedited in 2021 and 30% in 2022 so far. So there's a large number of cases that are actually going through expedited arbitrations, and we'll see if that trend continues to go upwards in the next few years. And obviously we haven't seen any through the new international procedures yet because they're just coming into effect in July, but at least domestically we're seeing a trend upwards with those. So where the expedited procedures apply is first if the parties agree, either in their contract or they come to that agreement, or secondly, as long as the claim does not, or the counterclaim does not exceed $500,000 exclusive of interests and costs. They do not apply where the parties have specifically agreed not to use them and to opt out of those procedures regardless of the amount in dispute, or where the parties have decided that they want an arbitral tribunal consisting of more than one arbitrator. So the rules are that it's one arbitrator for expedited arbitrations. If the parties want 3, it can't fall under expedited. And so the sole arbitrator appointment follows the same procedures that Ariel referred to earlier, but there are flat fee arrangements for expedited arbitrations. So if the dispute is under 100,000, the flat fee for the arbitrator, assuming there's no oral hearing, which I'll get to in a moment, but that flat fee is only $5,250. If the dispute ranges between 100,000 and 250,000, the flat fee is 10,500. If your dispute is between 250,000 up to 500,000, which is the limit for expedited, then there's no flat fee that's applicable. So it's really if you fall in that range of 250,000 or less that you have that cap up to 10,500. And so what that does is that actually opens up the availability of which arbitrators you might go with. And so you may go with someone more junior and slightly less experienced for an expedited arbitration because of that flat fee. It's not going to be as appealing to some more senior arbitrators, but we do have a roster of expedited arbitrators that have been approved for expedited arbitrations, and they're arbitrators that are younger, a little bit less experienced, but willing to do that for that flat fee. The arbitrator does, however, have the option to refuse the appointment after they've reviewed the notice to arbitrate and the counterclaim. And where that may happen, or where the parties may choose to opt out of expedited arbitrations, regardless of the amount of money at stake, is where the issues are actually complicated enough that regardless of the value of the arbitration, it's not gonna make sense to go through the expedited procedures. And so there's a trade-off for that shorter period of time, which impacts the scope of the proceedings in return for a speedier outcome. But if the parties enter into the arbitration with unrealistic expectations, it can cause frustration across the parties, the arbitrator, and the council as well. And so it's something just to keep in mind that not every kind of dispute is going to be suited for expedited arbitrations. So the timelines that apply under expedited arbitrations. The arbitrator, after its appointment, his or her appointment, will be appointed within, they will be appointed and then issue the procedural order within 14 days of their appointment. So that first procedural order that sets the schedule is 14 days from appointment. And here's one specific thing about expedited arbitrations that's special. The default is there's no oral hearing unless the parties agree otherwise, or it's directed by the tribunal. And one party can apply, or both parties can apply for an oral hearing, but that application goes to the arbitrator to determine whether it's necessary to have that oral hearing. If there is an oral hearing, it's limited to a maximum of 1 day, except in extraordinary circumstances where it may be more than 1 day. And then that flat fee structure that I mentioned earlier is not going to be applicable for the oral hearing. And so we have a fee schedule at the back of our rules, or hyperlinked to our rules, and that provides what the hourly rate of the arbitrator will be for that 1 day oral hearing, or if it's more than 1 day, but again, only in extraordinary circumstances. So unless otherwise agreed to by the parties or directed by the arbitrator, all written materials in the case are going to be exchanged no later than 120 days after the appointment of the arbitrator. So you're targeting a very short period of time from beginning to end to exchange all your materials in the case. And of course, the parties may agree to a procedural timetable that's slightly longer than that, but that's the goal. And then after the exchange of all written materials, it's only 10 days where the parties have a chance to apply for those oral hearings. Under our domestic rules, only 8% of expedited arbitrations have actually had an oral hearing. And so most people, at least under the domestic rules, are keeping it to written materials only. And then the award is going to be issued within 45 days of the last written material. And if there's an oral hearing, it's 45 days after the close of the proceeding. So very short turnaround time to be getting your award. And our domestic rules provide for 30, the international ones are 45 days. So the last thing I'm going to say is we have a roster of 75 arbitrators that are for international arbitrations. We are always looking for people who have international arbitration experience to join that roster. And the fee to apply and to join for that roster is $225. And so if that is something of interest to you, we'd encourage you to apply, and then that application is considered based off the experience that you have.
Thanks, Alex. It's interesting. I actually didn't know the 8% figure for oral hearings, but that's encouraging, because the point is a lot of times you don't need that oral hearing. These matters can be decided as a contractual dispute, interpretation of a contract. You might not need cross-examination. And obviously 92% of people are agreeing that they don't need it. Yeah. On a fair number of arbitrations, there's a fair number that we've seen going through the expedited procedure. So that's encouraging. We hope to kind of bring that experience into the international rules as well. Thanks.
So I think with that, we're going to open it up to the audience for questions. And I think online audience has the ability to ask questions as well, Joe.
In the chat, I think that's right. I think I've got a chat function here, so that probably means someone could.
Ben?
So there's at the outset that there was sort of this tension in other jurisdictions that are having to deal with sort of more excessive rules. Do you think that there are any parts of the rules that you've sort of changed, maybe like the ex parte portion that will sort of cause controversy or that might dissuade people from going with that to sort of continue forward?
Well, I think actually we were concerned on the ex parte one that I think we included, I should probably check before I say this, but I think we included a kind of caveat as to the, so at the very beginning of the ex parte preliminary orders, unless prohibited by law or otherwise agreed by the parties in writing. So, you know, if there are places where you actually cannot do that, we've taken that into account and said, well, that won't be available in that jurisdiction. But most of the rules, what was missing, especially when we were looking across Canada, was kind of some very basic procedural stuff that's now found in the BC Domestic Act that wasn't there before, that we had taken out of our domestic rules, because you don't need to repeat. If the rules and acts both apply, you don't need to repeat it in the rules. But what we had was the rules applied and acts without that, all those procedural meat weren't there anymore. So that's why we wanted to make sure that the international rules would fill that gap, so you could have an arbitration seated in Calgary, Toronto, or wherever, and be certain that kind of all the procedural stuff was taken care of in one set of rules.
So I have a question along the same lines for the audience benefit to hear from the two of you, Mil and Joe. What's I think quite common to see in arbitration clauses is to carve out any IP disputes from arbitration. And so to say everything under the contract except for anything that arises with respect to IP will go to arbitration, and anything with IP will go to litigation. And that's because in the past there hasn't always been the option under a lot of institutions' rules to be able to seek injunctive relief. In your view, is that still, are IP disputes something that should still be hived off, or is it something that should fall under the scope of the arbitrator's jurisdiction?
It's a really good point. I think in part, so I think in terms of whether it will, this wasn't your question, but in terms of thinking through whether that clause will appear perhaps less in contracts now that people know that there's this option of going to VanIAC or other institutions that are clear about the interim possibilities. I think it'll take a while. My experience with the drafting of contracts that include those clauses is that they're often just there. I don't think people really think through that much why they're included. They're just lingering boilerplate, no offense at all intended to anyone who's drafted those contracts, but they just subsist. So I think it'll take some time to have that overcome in any event. I think my own sense is that at least people would like sort of an express off-ramp, particularly if there's intellectual property that might be used by someone who's not a party to the actual contract itself, that there's an ability to grab onto people who might be, you know, the immediate wrongdoer in the dispute might be the party to the contract that includes the arbitration clause, but it may be that then the technology, the know-how, the confidential information has reached further. And so there might still be some merit in having a clause like that, just to make clear that both the other contracting party and the people who have received the information can be pulled into one forum to be dealt with together. But, you know, certainly I think it's a really, it shows that contracts that include arbitration clauses need to be carefully thought through when sometimes they're not. And that's, I think, a good instance of why people should actually step back and think about, well, you know, do we still need a clause like that? Should it be refined? Should there be some recognition of rules that are expressly imported that deal with some of the concerns? And it's just it's a good drafting practice to be thinking through.
Yeah, and I'm definitely on the far side of encouraging arbitration for everything and not having carve-outs, because anytime I've dealt with a carve-out of any sort, it creates a disaster, whether it's sitting as arbitrator or as arbitration counsel. It's just, you'll fight as to whether this is actually, there's an element of an IP dispute here that's also part of this work. So you actually can't, and you get into this, you know, very difficult issue, and you get into jurisdictional issues as to whether the arbitrator how far the arbitration can go, and it's just a bit of a mess. And hopefully the idea that you can get the type of relief here will encourage people not to have those carve outs on IP. I mean, in my experience, a lot of that comes from drafting, which comes from the US in particular, with that type of a carve out. And then it's adopted by the Canadians because maybe you don't have a choice, depending on who really has the power in that drafting. But I would prefer not to. And the issue about the third parties, you know, it may be that you then have the two proceedings. You've got the arbitration ongoing, but at the same time, you've got the court proceedings with against the non-parties who are selling it at the Richmond night market or wherever, are selling the Cartier watches or whatever. But
Sounds like you have personal experience seeking an injunction in this
or
context.
buying a watch at the Richmond night market. Any other questions or comments? We have time, or we can, you know, have some wine and appies out there, or for you online, you can go off to do whatever you do. I didn't mean to discourage questions by putting it that way. Anything else?
Say that you did a great job. You struck the right balance between creativity and service.
Thanks very much, Jerry. And for those online, that was Jerry Geekas was just saying how great our international. So anyway, so we'll put that as a little stamp of approval. Thank you very much. And it was there was a fair amount of work that went into it, and it was interesting that we had to take sit back and kind of. Originally, we started. I will say that having been on the previous rules committee dealing with the domestic rules, I kind of thought it would just be some tweaks to domestic rules. And then when we sat back and realized we had to actually start from the beginning again, and adopt some of those new concepts in the domestic rules, but realize that we were dealing with a different beast. And so I'm looking forward to seeing them in action. Anything else? Anyone? Well, thank you very much to my fellow members of the Rules Committee that are here, and Craig, who isn't. And thank you very much for attending in person, and those that were attending online, thank you so much as well.